Let's bring in Bloomberg legal and politics reporter Eric Larson. He was in the court overflow room yesterday covering Trump's fraud trial, and professor of law at Columbia, John C. Coffey Jr. He's an expert on securities law and white-collar crime and author of the book Corporate Crime and Punishment: The Crisis of Under-Enforcement. Good morning to you both, Eric. I'll start with you. So you're in the overflow room, getting a sense of how things are playing out in the courtroom. How does this look right now for Donald Trump?
Well, I think the fact that he showed up, actually, it's a position of strength for him, which is kind of interesting. I don't think anyone was actually expecting him to show up until just kind of the last minute, and now we kind of see why. He was able to do a lot of that grandstanding, give that big speech outside of the courtroom, and every time there was a break in the trial, he was, viciously attacking the judge and the attorney general. So this is, helps him in part of his campaign, to be honest. Like, as you said, he's already been found liable for fraud. So the case is kind of in the state's favor pretty strongly, and the judge clearly has accepted a lot of what the state has to say.
So what kind of defense are you hearing from his legal team other than Letitia James is biased and the judge is a Democrat? Is there anything on the evidence where they're defending themselves?
Yes, they're focusing a lot on whether or not any banks were actually harmed by this alleged conduct. They're looking at these inflated financial statements, wildly inflated, according to the judge, from 2011 to 2021, and saying that these were submitted to various banks, Deutsche Bank, others, and to insurers to get better terms on loans and policies for years, and that he reaped $250 million in illegal financial benefits as a result. But he says that these banks were not harmed at all. He paid back all these loans. They actually made $100 million in interest off of him. Both sides are calling bank employees as witnesses because they both think that they'll be able to back up what they say. And at the end of the day, even though he has been found liable for fraud before the trial, there are other significant claims, including falsified business records, things like that, which the judge theoretically could still rule in his favor on.
So, Professor, let's set aside Trump's hysterics outside the courtroom and talk about the merits of the case being tried within it. What have you heard so far from both the state attorney general as well as Trump's defense team? And how strong do you think these claims are? We know he's been found liable, but for how much?
Well, I mean, the judge has appointed receivers who still have to be named, who are supposed to liquidate all these companies that are within Trump's organizations. The one thing I think you are missing is that, petulant and silly as Trump seems, he's probably being rational from his own perspective because he wants to exploit this trial as an opportunity to show again that he is the victim of political persecution. That's been his main theme, and it's actually raised his popularity in the Republican primaries. So he's figured out that I'm going to go to this trial. He almost never has gone to civil trials, but he's doing it because this is a way to raise his theme that there's a persecution going on and you should raise an arms and support me because we're being attacked by the evil government.
So, Eric, explain, if you could, what exactly has been decided and what still has to be decided in this case, and how long the punishment phase of what has been decided could take.
Well, the judge has said that this trial is going to go until December 22nd. So we can expect a lot of evidence on whether or not these 6 remaining claims Trump is liable for, whether or not he conspired to falsify these business records, whether or not they were used in specific transactions in a way that harmed these banks. And then insurance fraud is another claim in there as well. But then there will have to be more arguments on whether or not the full $250 million has to be disgorged and whether or not Trump and his 2 sons, who are also defendants, would be banned from being directors or officers of any New York-based company. And as the professor just said, there's this whole other aspect that has to be decided outside the trial on this fraud claim that's already been against Trump. We really don't know how far that's going to go, what the full outcome will be. Even Trump's lawyers don't know, and the judge hasn't really clarified what it means that all of these companies are going to have to be dissolved once this receiver is put in place. But right now, there are 5 more claims that the judge has to decide on liability for, and then based on those, he'll go into the penalty phase.
So, Professor, I spent the day listening to commentators who can't seem to get over their fealty to Donald Trump. And one of the arguments they made was that, oh, my gosh, if this is so political, if this attorney general can do this to Trump's business, he can do it to your business, too. I'm curious if you could put into context these fraud allegations that he's accused of, and some he's been found liable for. How do they compare to other white-collar crimes in their severity and their size?
Well, you have to understand that the Attorney General is operating under a unique statute that authorizes her and no one else, not private plaintiffs, to dismantle, to liquidate a company that is engaged in persistent fraud. She does not have to prove that anyone has been damaged. She only has to prove this company has persistently defrauded people, in this case by inflating its assets, and because you're a persistent fraud, we're going to throw you out of New York State. That was the intent of the legislature, but this is a statute that applies only when the Attorney General brings the case.
I'm curious, from what you have seen, do you believe the Trump organization has been, is it likely that they have been engaged in, quote, persistent fraud?
Well, I think the inflation of assets has been shown. He granted summary judgment, and there was lots of evidence. We've heard the stories about calling a 11,000-foot apartment a 30,000-foot apartment so that you could get a higher valuation on it. They are treating rent-controlled buildings as if they were the same as non-rent-controlled buildings. That's the way to inflate assets. The evidence there was pretty strong because he granted summary judgment, and he's an experienced judge. You don't grant summary judgment unless you believe there is no fact in this case that really has to be further resolved. It is all clear. All that's really left now is the penalty.
Yeah, and that sounds certainly, Mika, through the years, like persistent fraud.
Professor at law at Columbia, John C. Coffey Jr., and Bloomberg's Erik Larson, thank you both very much for your reporting and analysis this morning.